Well, hello everyone. Welcome to this new webinar. We're here today with Ruby Powers from Powers Law Group, and today we're going to talk to you about understanding the writ of mandamus. So Ruby, she is an immigration attorney. She was licensed since 2008, and she founded the firm in November of 2009. She has received many mentions as an immigration lawyer. So Ruby, the word is yours.
Thank you, Maria. So everyone, we're talking about the writ of mandamus, which it's Latin for basically, in this case, we command. And what it might sound complicated, but what we're seeing is an opportunity to speed up a case that's been taking too long. And USCIS has premium processing. You pay a fee and you can get a decision within a few weeks or so, like that. But if you really, really have to, this is a legal remedy or court order used to compel a government official, public authority, or lower court to perform a specific duty. And this is something that we've only had to do a lot more in the last couple of years. Um, we had maybe threatened to do this in the past, and that was good enough, but we've had to actually do it to be able to see the result. So I'll just tell you, people might think, oh, I don't want to hurt my case. No, this doesn't impact your case in terms of a decision because of filing a lawsuit. The lawsuit brings to attention your case if you've exhausted your remedies, and then the adjudication of your application is in a separate space, and it is not, other than the fact that the speed and the compelling the action is not taken into effect in a decision. There's not like a retaliation, if you will. I think that's what some people think. They either don't know what writ of mandamus is, or they're like afraid that it's going to somehow affect their case negatively. So it empowers individuals to enforce their legal rights, break free from the delays, compelling the performance of duties, and restoring balance of fairness. So, we really only got into this a lot more the last couple of years just because it was necessary. And for the clients that we've been able to help, they've gotten on to getting their decisions on asylum, applying for green cards, getting their waivers approved. We've been doing this for everything from asylum pending for 5 to 8 years, even less in some cases, to being able to for I-601As, and to also for I-601 waiver, and an I-730. So that was taking 2 or 3 years. So we've been able to do this for a lot of different case types in the last couple of years. And just in general, I'm actually admitted to multiple courts within Texas. I'm about to get admitted to the last of them in the Western District shortly. We'll talk about the jurisdiction in a moment. So the petitioner must clearly identify the petitioner, who the individual entity seeking the writ of mandamus. The respondent is the government agency, so depending, it could be USCIS, Attorney General, FBI, DHS. So it depends on the case type and where you're located. Jurisdiction is the court in which it's being sought, and then you're proving that there's unreasonable delay. For the most part, for asylums that have been pending more than about 3 or 4 years, you pretty much don't have to do much more than just show that it's been pending that long. For other case types, you need to show that it's either potentially outside of processing times, or it's unreasonable, the amount of processing time. So you need to show that you've exhausted administrative remedies, you've requested relief, and you have the supporting evidence to back it up. And when we work on these cases, we explain all this in detail to that specific situation for a client. But really, like, if you've sent emails, you've called, you've reached out, you've involved the ombudsman, depending on the case type, you've really exhausted your remedies, then it's time to go to mandamus. In some cases, you don't even need to do all of that, if it's been many, many years. I'm thinking mostly about asylums, which, asylums have been moved over to the first in, first out in January 2008, which, wow, 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 that's 6 years ago this month. And since then, cases that were filed back in like 2015, 2016 are completely at the very back of the line. And the only way that many of them are getting interviews is through being on a short list in some parts of the country or being filing a mandamus. So it's statutory. There's the Mandamus Act, and there's also the Administrative Procedures Act. And you're explaining that this is the only way you could move forward and you've exhausted your administrative remedies. So where do you file the lawsuit? It's the district where the plaintiff resides. So if you are in Texas, we can help you. Even if you're not in Texas, we can help you too, because we can team up with another attorney that's licensed or admitted into the district in which you are residing, and we can do what's called a pro hoc vice, and we can team up so that they can help us file in that court. Every district court has their own rules. A lot of times you have to be licensed in that state sometimes, and then get admitted on top of that with certain things like affidavits, attorneys vouching for you, good uh what's it called, recommendation letter from the state bar, things like that. But don't have to worry about that. We just really need to know where you live and where your file is at. And then we could team up with an attorney if necessary. And so these are just some things to consider, and that's really important. Now, if you're moving, we need to wait till you're done moving, or maybe file before you decide to move. So those are some things to consider. The Mandamus Act compels agencies to act. Basically, it's like, hey, we've done everything. We can't get a decision. You're the only one who can make this decision. If we could go somewhere else, we would, but you're the only person, the only entity that can do this. And we're explaining that the plaintiff has a clear right to the relief request, the defendant has a clear duty to perform, and there's no other adequate remedy. And the APA, so Administrative Procedures Act, creates a cause of action to sue where not specifically permitted by statute. So the gist of this is that and the APA is instructing courts reviewing regulation to invalidate an agency action found to be arbitrary, capricious, or abuse of discretion, otherwise not in accordance with the law. So we generally explain that we're doing filing it under APA and mandamus, but it depends on the situation. And so there's some cases that you can't sue, but at the same time, there might be still a way to get around that and find a way to do it. So this also could be done in consular processing matters in certain circumstances as well. So the plaintiff is the client. Defendants can depend on where the case is. We're talking the asylum office, or are we talking FBI, Secretary of DHS, Attorney General? Is it a National Visa Center matter? Things like that. So, oh yeah, we also did sue the National Visa Center for a CESPA matter. So anyway, this is what we work on internally in our office, deciding who. So if you get hired us, we would draft the complaints, we would have to do all of the case form and filing, and do the processing, and then we would wait to hear from the government. For the most part, what we see is that the government reaches out to us, AUSA attorneys, and they are saying, if we can get you a decision on your case within 120 days, would you dismiss this lawsuit? And for the most part, our clients are willing to do so and not going forward. So that's really the crux of the case. It's not the intention to go all the way, because if you did go all the way and you won, you can retrieve attorney fees. But a lot of our clients are just focused on just trying to get the decision, and that they're happy with that. So, bringing a strong case, we want to document what you've tried to do. You called, you emailed, you did a service inquiry, you did an ombudsman report, you did InfoPass. What did you do? You emailed the asylum office, whatever. You want to show that you've tried to exhaust your remedies. And like I said, each case type has their own things that we should do and best practices. So, and when you have a consult with us, we can explain that. And you want to make sure that it's persuasive, and and explain that you've been waiting for this decision and it's either outside of processing times or you've exhausted our remedies or it's ridiculous how long it's taking. So in summary, the writ of mandamus is a really great opportunity to speed up your case, depending on your case type, depending on how long you've been waiting and what you've done to try to speed it along. In a way, it almost acts like a premium processing because it moves the case forward. We have tried to find a way to do a balance with our legal fee. Most of the filing fees around the country are around $400 to $500. So that's another thing to note. There's legal and filing. But the other thing is that if you're planning to do this, you will see results and you will see movement with your case. This could be done for trying to get a case moved around from one agency to the next. It could be to schedule an interview and get the decision. It also could be that you've had the asylum interview, for example, but they haven't made a decision because whatever the backlog reasons are. We've done several cases like that as well. So we have a lot of experience. Again, we have 4 full-time attorneys and a couple of part-time attorneys as well. And many of us have worked on mandamus cases in some format, in some way, and are also are well-versed in interviews and asylum, family, naturalization, I-730s, etc. So I just really want to make this a big push because if this is something that you've been waiting a long time, just at least have a consultation to evaluate whether or not this is something that we could help you or someone could help you with. And if this is something that interests you or maybe a friend or family member, feel free to share it with them so that they know as well that this opportunity exists. And I just want to sort of demystify this is not as scary as it sounds. It does sound scary like suing the government, but in reality, we've done it a lot and we've had highly successful results. And all of the clients are, just excited that their case is moving forward and they can have that sigh of relief. And in most of the cases, they're moving on to the next step and being able to move on with their lives. So that is really what we like seeing for our clients. I wanted to share that with you today. So you can reach us all these different ways. From Twitter, Facebook, newsletter just went out today, to Instagram, to TikTok, and we're putting out videos and content regularly. And we just want to be a resource for you. This is our last mandamus, this is our last webinar for the month of January. We have a lot more exciting ones coming up in February. But thank you so much for watching, and we'll see you next time. And just definitely, if this is interest of you, please reach out to us because we can help you with your case. Thanks.